All right, I'll wait till you guys finish your Facebook stuff or whatever you do. Couple of admin things. Apparently there's some kind of seminar list which has appeared on Keats. Please ignore. That's wrong. So please don't. I got a pile of emails on that. Just ignore it, okay? There will be a new list going up, which I'm going to put together. There will be 6 seminar groups, repeat 6 seminar groups, meeting fortnightly, meaning every 2 weeks. I won't say bi-weekly because bi-weekly in English means twice a week. To our good North American friends, it means once in 2 weeks, but to us it means twice a week. So it's fortnightly, okay? What I need to do is to assign you to a group. Now, the problem that I have, and it's all in the emails that I got. Gosh, I can't come today, I can't come tomorrow. I've got archery classes, I've got scuba diving classes, blah, blah, blah. So what I want to do, remember this list that you filled up last week, your name, etc.? I'm just going to send it around again, but this time all I need you to do, and please pay attention, note the time at which you cannot, repeat, cannot attend seminars. Okay? There are 3 seminar groups every week, Tuesday at 4, Tuesday at 6, and Wednesday at 5. Okay? Tuesday at 4, Tuesday at 6, and Wednesday at 5. All you got to do, next to your name, say not T4, not T6, Tuesday at 6 or Tuesday at 4, whatever, right? That's it. But I need you to do that. Okay. No, didn't understand. Please ask what the question is. Please ask. Your neighbor is not going to know the answer. Did you follow what I was saying to you? Clear? Okay. Right. Could you take this around for me? All you need to do is pass it down and get everyone to sign up. Yes? Or you can remove it. And hey guys, do me a favor. I get emails with everybody asking me the same question. Okay? So what I'd like to do is to answer the same question to all 10 of you in class. So that'll save me 10 emails answering the same question. If you've got a question, just ask, okay? It's perfectly okay. At whatever time you want, raise your hand and ask. I'll be very happy to answer it, or if you want to talk about it immediately after class or immediately before, just tell me, okay? Then I can talk to 5 people at the same time. By the way, guys, your email writing has got to improve if you're hoping to get a job. Gee whiz. The number, I look at them and I think, gosh, you're not kidding me. You're not going to send emails like this in the future for jobs. Okay, dear Professor Tennakoon, that's fine. But then the only thing you haven't said yet is, hey, dude. Everything else you've done. The funniest one is, dear Mr. T. Any of you guys watch TV? You watch a program called The A-Team? There's a Mr. T in there, and he doesn't look anything like me. He's 10 times bigger than I am. So can you please just use the standard format rather than, hey dude, hey Mr. T, whatever, right? Dear Professor Tennakoon will be fine. Gosh. Okay, right, so this list is now going around. All you got to do is, against your name, say not Tuesday 4, T4, not Tuesday 6, T6, or whatever problem you've got. But please, it's got to be on some basis other than, I've got scuba diving classes, okay? Lectures. Okay, done. Bless you. Yeah.
Professor, is it going to be for the first semester because the
Yes. There's one group which will have to be reassigned next semester because the lecture times and the seminar times are changing. I'll try and sort that out as we go along. It's a nightmare, this whole programming of timetables and so on and so forth. But we'll get there, okay? Right, while everybody is staring at this list, I'm just going to do a very quick recap on what we did last week, okay? What I was trying to do last week was to deal with the problem that arises in all forms of international financial transactions, namely the possibility that more than one law system can affect the transaction. Not only the possibility, the high probability that it does. Now, the question is, how do we deal with it? And like everything else in international financial transactions, there is no treaty, there is no convention. It's up to the global law firms to sort it out. And that's what Goldman Sachs and ExxonMobil and Hyundai expect the law firms to do. Sort it out. Give us a solution. Don't ask questions. So the solution that law firms have come up over the last 25 years or so is to try and insulate, and that's the key word that you need to remember, insulate each financial transaction from the applicability of too many systems of law by expressly choosing a single system of law to try and control as many aspects of that transaction as possible. It's not to say that expressly chosen law will control all aspects of the transaction. No, it can't. What we can do, however, is to try and control as many aspects as possible by this chosen law. Now, in practical reality, over the past 25 years, the practice has grown that the markets have chosen English or New York law to be used to achieve this insulation. Now, if you remember, I said to you that insulation depends on two things, how effective your insulation is. First of all, when you choose a law system to control as many aspects of a transaction as possible, you need to look at that law system and say, well, what aspects would this chosen law system actually control? And the second important question, will other law systems recognize the control of this chosen law system? Okay? Those are the two things that the markets have looked at over the past 25 years, 30 years, somewhere down there, to decide where they want to go, what law systems they will use. Now, the control aspects is easy to work out because you look at the law system and say, okay, tell me what aspects will your law system, if we choose it as the chosen governing law, control in this transaction. Now, for us, that will depend on the nature and the type of law system that we choose. And I walked you through the various systems of law, but I said what I will do, however, is to pinpoint that under English and New York law, and I can't do it, all of the law systems on the planet, certain matters are controlled if you choose English or New York law in relation to a transaction. The control of English law over a transaction is actually dictated not by English law rules, but by the Rome rules of the European Union. Mind you, even after March, if Brexit goes ahead, it will still be the EU Rome Regulation 1 which will control, if you choose English law, what aspects of the transaction will the chosen law system, English law, control. Now, I've got it just down there for you to look at, Rome rules. By the way, somebody asked me, can we please have reading on Rome rules? No. The straight answer is, you're now a postgraduate student, and in about 10 months' time, you'll be working in a law firm. So first suggestion I have is, when I say Rome rules, press a button on Google, and out will come the Rome rules. So just have a look at it and read it, because sooner or later, you're actually going to have to look at these rules rather than what I say or what's in the book or whatever, okay? So just start doing that. It's a good practice. Okay, so these are the things that will be controlled by English law if you choose English governing law, and it will be done on the basis of the Rome regulation. Now, many other common law systems have still got the old English common law, that is to say, the US rules, the Canadian rules, the Australian rules. They're all based on the old English common law, which essentially means this. There's no difference. And I walked you through the Uniform Commercial Code in the US, which actually reaches the same kind of conclusion. On recognition, however, there's a difference. English law has got the support of the European Union Rome Regulation, which means that for 27 states they will recognize it across the Union, even after Brexit. Because that's what the Rome Regulation says. If you choose a law system expressly, the Rome Regulation requires all courts within the European Union to recognize that law system. Now, does that happen outside? Yes, it does. How? Because there are conflict of laws rules, and this is where you need to go. Supposing you're trying to work out what happens in Singapore. Will it recognize English governing law? Answer, yes, because Singaporean rules are actually using the old English common law rules of recognition. The same is true in the US. So you'll have, quite apart from the EU-based recognition given to a chosen governing law, the conflict of laws rules of what was the original common law still survives outside the European Union and in the common law states. So that's really the starting point of our exercise as lawyers. So once we've got that, we have to look a little bit closer at whether or not there are limitations within the law system once it is chosen as a governing law. For example, if you choose New York law, there used to be a rule that New York law could not be used as an express governing law unless there was a close connection with New York and the transaction in question. That, however, is now gone because of the General Obligations Law 5-1401 and been applied in a recent case in New York. Doesn't matter, the case isn't important. But there it is. The close connection rule is gone in New York. Does it exist in our law? Well, let's look at what happens. Rome I doesn't actually have a close connection rule saying the law system must be closely connected to the transaction. It doesn't. The only exception it has is that if all elements of a transaction are connected with a law system other than the chosen law, then that other law system with which the transaction is completely connected, all aspects, that law will prevail. And as I pointed out to you last week, that rule, the Article 3 rule in the Rome Regulation, is irrelevant in international financial transactions because, by definition, it's an international financial transaction, which means multiple jurisdictions will touch this transaction. Transaction will be connected with more than one law system. So the only exception that we find in the Rome rules is what is called the law of the place of performance rule. Namely, that if there are rules at the place of performance chosen by the parties, then those rules, if they are quote-unquote mandatory, must be given effect to under the Rome structure. Now, it is important to look at that question because there are many situations in which the place of performance may have rules which makes performance illegal in that location. And the example I gave was Argentina. New York law controls most Argentine loans, most Argentine bonds. But if the payment obligation under those loans and bonds is Argentina, New York law would say, no, sorry, we will give recognition to the laws of Argentina, overriding New York rules with regard to the chosen law. But that depends on whether Argentina is the chosen place for performance. In practice, that would never be the case because of this rule, the override. Now, this rule about the law of the place of performance, you find it in Article 9.3 of Rome, at least. That's the rule which we will apply in English law and certainly right across the Union, meaning all of the European Union states. In all common law countries, including the US, the rule is exactly the same. Because, hang on, whoops, where is it? Let me try and give you the case on this. I think I walked you through this last time, but I got a feeling. Right, I mean, I think I made this point earlier, but I cannot remember at which point I made it. Anyway, I'll come back to it if I can't find the actual location of that rule. But suffice it to say that in common law systems, other than English law, the only exception would be the law of the place of performance. If that law has mandatory rules, that must be given effect to override, supersede the chosen governing law. Okay? So that's the basics. And then I got on to the other factors which actually influence the market's decision, and nobody else's, the market's decision to choose and work with English and New York law. And right up front, if you ask an investment banker or ExxonMobil or Hyundai, why are you using this stuff? They're not going to give you all this stuff I just told you about conflict of laws rules and the applicability of the Rome regulation, blah, blah, blah. That's we as lawyers. For them, the markets has only one major need. Is the chosen law system going to provide us with absolute certainty and predictability of results in relation to this transaction? In other words, that concept translates into if our lawyers draft a 300-page document covering every possible situation that can occur, will that be given effect to without question? Because the global markets, more than anything else, need certainty, absolute certainty. And that's not just in loans. If you look at the bond markets, the derivatives markets, the securitization market, I don't know whether any of you have gone into a investment bank. It's got banks of television screens, television monitors, right? There are guys sitting in front of them working at it. And on those screens are prices, whether it's euro against dollar, whether it is price of gold, whether it's shares, whether it's Argentine bonds, there are prices. Why is it important in that context to have this absolutely certain and predictable? Because at any one given point in time, the markets need to know what is the position under the documentation. At 3:46 p.m. New York time, not later, not earlier, exactly at that time. Only a law system which can say, according to the documentation, that's the result, N. And that means being able to rule out all of these other things that lawyers talk about in the interest of justice. Are the consequences of the breach important? Are they serious? Has the default or breach occurred because it's somebody else's fault, not the party's fault? Is it unfair to the borrower of a loan, the issuer of a bond, to apply the rules, the clauses as written? You cannot have that. Markets do not want judges to second guess what investment bankers and their lawyers have decided. Any law system which does that, don't want to know. It's as basic as that. You and I as lawyers think, hey, what happened to justice and what happened to truth and all that kind of thing? The markets are not interested. There's one thing they want, result predictability and certainty. And if that's an unfair result, so be it. The question is, does the law system allow that result to be reached? And the reason, one of the main reasons for the choice of English or New York law is exactly that you're not concerned with this justice concept. Essentially, English common law and New York law imposes strict liability for any breach of any obligation contained in a transaction document. Any deviation and you've got a breach. It's as simple as that. Judges will not interfere. There are case after case saying we will not interfere on the grounds of reasonableness, fairness, absence of loss, etc. Which is quite different from the approach taken in many continental European law systems who are far more concerned with this concept of justice and fairness, which English and New York law, strangely, at least in the commercial world, does not subscribe to. So that's one of the major reasons. And if you look further into the doctrines that are applied, you'll see that English and New York law do not actually have a doctrine of force majeure, do not have a doctrine of onerous performance, which you have in many other comparable law systems, sophisticated law systems. That is not something that the markets like to see. If they want force majeure to apply to a transaction, they want it included as a specific clause, not put there by legislators or judges or anybody else. Right, moving on. I think I stopped at the point where I said, look at the question of cross-default, which is a standard clause in every financial market transaction document. Can I deal with your question after I deal with cross-default, or do you want to have a question right now?
It was about the governing law.
Okay, go ahead, please.
The governing law, is that only relevant when we're talking about we don't want these status situations? Like, is it also relevant sometimes to the forum?
It's relevant to?
Is the forum also relevant?
I'll come to forum. I'll come to forum, jurisdiction, in a short while. This is simply the choice of a law which is going to give the markets, the investment bankers, the pension funds, the hedge funds, the certainty they want in financial market transactions. That's really what this is about. Now, as lawyers, we will say, okay, we can achieve that with a law system which we will choose, which will insulate this transaction from being battered by asteroids which have nothing to do with the transaction, meaning other law systems. And that's why we were talking about the level of insulation that a law system can provide. And that also, as I pointed out 10 minutes ago, also depends on recognition of the control of the governing law of a transaction by other law systems. And that's why Rome I, the Rome regulation, is extremely important from the point of view of English law, because it gives recognition across the Union, 27 states, of the chosen law system. Now, one example of this process of disregarding truth, justice in the American way and just applying the rules as written, one of the best examples of it is to be found in the applicability of the cross-default clause. And I'm going to explain that very briefly. We'll do that in detail later. In every financial transaction document in the markets, there is, and you will expect to see, a cross-default clause. It's drafted in many different ways, but the fundamental is this. Say you are a borrower. You've got an Argentine corporation which is a borrower in a syndicated loan agreement under a transaction document. It will have a cross-default clause which will say, put it in very simple terms, if you breach this agreement, you're in default. Easy. 2, if any of your subsidiaries and associated companies or any other company listed in the annex at the back of this document breaches any of their financial transaction documents, you are in breach of my loan agreement. So what happens in practice? You will specify who's within the cross-default clause. Usually every subsidiary, every associated company of the borrower. In a loan agreement and in a bond issue, the issuer, its subsidiaries, its associated companies. That cross-default clause is fundamental to the way investment bankers and corporations approach international financing. Because that's a financial judgment thing. If a major subsidiary breaches a financing arrangement or document or transaction, then you, my borrower, you, the bond issuer, are in breach of this document. That's fundamental. Now, the question is, can that clause be effected, enforced, without question, without qualification, without judicial interference? And the reason why banks and corporations want that question answered with an absolute clear yes is go back to those television monitors, the screens. They are blipping. The bond value is going up, down, up, down. Derivatives value going up, down, up, down. So when a breach occurs and a cross-default occurs, you need to be able to press a button and say 3:46 p.m. New York time. That's the time at which the default occurred. Certainty. Absolute certainty. There is no time to say, oh, well, we better go and talk to a judge somewhere. Nobody wants to know who these judges are. Really, what you need is a document which says, that's the law, that's the breach, and that's our remedy. No questions. That's the cross-default clause. Now, it can extend hugely. For example, in certain types of transactions, not only are breaches of other documents, transactions by subsidiaries and associate companies included, Sometimes major counterparties, business counterparties are included. For example, just to take an example, if Airbus, does everybody know what Airbus is? It's a bus in the sky. Okay. The cross-default clause on an Airbus syndicated loan or an Airbus bond issue would not only refer to its subsidiaries and associated companies, it will also refer to its major suppliers. For example, Rolls-Royce, which is a completely independent company, is a major supplier to Airbus. Now, a bank lending to Airbus will say, hang on, if Rolls-Royce gets into difficulty, Airbus is going to get into difficulty. Therefore, I want a cross-default clause which says, if Rolls-Royce is in breach of any of its financing transactions and documents, then you, Airbus, are in breach of your agreement with me. Do you see how it works, the basics? If you don't, please, hands up and ask. Yeah.
So what's the logic behind having these so fundamental contracts, especially when they relate to...
I think first thing we need to get away from is that use of that word contract. Okay. Let's keep it to bonds, keep it to syndicated loans, whatever, because these are specialized transactions and therefore with specialized clauses. Yeah, go ahead, please. Your question.
So you said like they are happening fundamental to transaction documents. I'm wondering what's the logic behind having that? Like, why are they so important?
Why is what important? The clauses?
Why are they cross-default clause including with all subsidiaries and why is so important to have?
Well, if you think as an investment banker or a banker or a pension fund, the reason is very simple. You are lending funds, either in a loan as a group of banks or as an investor, a pension fund, hedge fund in a bond issue. Essentially, you're a lender to this entity. If that entity gets into trouble, you don't get paid. You lose your money. Right? So you have a whole list of things which will constitute a breach and a reason to terminate your agreement with this borrower. On top of that, pension funds, hedge funds, investment banks think that it's not just that entity that we are concerned with. It's everybody connected with that entity. Because if one of them goes into default, it's more than likely that my borrower, this bond issuer, will go into default. That's why I gave you the example of Airbus and its intimate connection with Rolls-Royce and the need to say, if Rolls-Royce gets into difficulty, then you, my friend Airbus, you're in default of your transaction with me. That's the logic of it. Yeah, are you guys clear now? Now, the problem is, the cross-default clause in the way that I've described it is capable of being attacked in many jurisdictions, which is French law-based, Italian law-based, or German law-based. Anyone from Germany? No one's going to answer this question anyway. And there are no French lawyers either, right? No French lawyers, no German lawyers, Italian lawyers, none of them either. All I need you to do is tell me, thinking back from your knowledge of your law system, would that cross-default clause be capable of being attacked in a court as being unfair, unreasonable, or whatever? And that's where the problem lies. Under some law systems, although the clause is valid, it is capable of being challenged in a court of law on the grounds of unreasonableness, on the grounds of unfairness. That cannot happen, will not happen under English law and New York law. Cannot be attacked on the basis of unfairness or unreasonableness. And that, if you want one of the major reasons why markets prefer these two law systems, it's the validity and effectiveness of the cross-default clause, which will not be questioned under English or New York law. And it's fundamental. Yep, your question.
About the breach of from the associates or from the subsidiaries, is this breach important, or if it has a reflect on mine? Because as much as I think
I keep coming back to this point. It doesn't matter
reflect,
whether it is material, serious, whatever. If I define a breach as a breach by a subsidiary, an associate, a supplier of their financing arrangements, that's it. Under English and New York law, nobody is going to say, is that breach serious? Is that breach going to affect this person? Irrelevant, irrelevant, irrelevant.
Kind of, if I pay you what I meant to pay, and if you like better breaches something, it's still
It is still a breach. I mean, I know it's a very difficult concept to understand if you're from a law system which believes in justice or fairness. I think yes, you're right. I'm glad you raised these questions. But thinking just a breach is enough. It's more than that. It's more than that. Let me give you an example which we always talk about at the International Bar Association's conferences between German lawyers, French lawyers, Brazilian lawyers, and on one side, and the English and the New York lawyers on the other. Standard clause in a syndicated loan agreement or in a bond issue is payment shall be made at 2 p.m. New York time or 10 a.m. London time. Breach of it gives you a right to call default and terminate the transaction. So the question our German colleagues and Brazilian colleagues would say, so what happens if the money comes in 5 minutes late? And the answer that all of us would give is breach. Right to terminate, full stop. No question of unfairness, no question of unreasonableness. The right is there. Whether the banks will exercise it is another matter. Of course they will. But as a legal, technical matter, the answer is if you want to default your borrower or the bond issuer because it's 15 minutes late on a payment, yes, you can. That's how harsh the law is, but that is exactly what the markets want. I'm not interested in what you and I would be interested in. Hey, it's unfair, it's unreasonable. What the heck is this? Where's the justice in this? Yeah?
If the money comes 10 minutes earlier?
Latest by 2 p.m. New York time. Okay. If you want to pay earlier, you can. But nobody will. I'm sorry. Yes. Sorry, you got a question there. I think you need to now think practically, and that means coming up with a fact scenario which is clear. So what is the fact scenario that you've got in mind? Transaction is in China. What do you mean by transaction is in China? What part of the transaction? Performance is in China, okay. Okay, the governing law clause will nevertheless, if it's English or New York law, control all aspects of the transaction, including performance, even if it happens to be in China. Stop. Now, if there's the relevance of performance being given and required to be given in China is this. If under Chinese law, for example, there's a mandatory rule saying you will no longer pay dollars to US corporations as long as Mr. Trump is the president. It then becomes unlawful under Chinese law to make that payment. Now, assume you've got English governing law or New York governing law, you then have to ask the question, well, how effective is that rule, the Chinese rule? Answer, will it be recognized? Answer, yes. Under the law of the place of performance rule, under the Rome Union, Rome Regulation Rules, Article 9.3, or under the US Uniform Commercial Code rules, which are essentially the common law rules, which says if there is illegality by the law of the place of performance, the governing law will recognize it. For that very reason, the real life scenario is that if you've got a Chinese corporation, your place of payment will either not be China, or it's China plus New York, London, Frankfurt. Because otherwise you do run into this problem. And we'll come across this over and over again as we keep going. But that's the reality. Moving on. Okay, one more question. Yep.
To the example of Airbus and Rolls-Royce. So if Rolls-Royce is in breach of an agreement...
With somebody else?
Yeah, with party A. With A. Then if there is a cross-default clause, does it have to be that Airbus will be considered to be in breach with an agreement between Airbus and party A, or even a...
No. We're talking about Airbus as the borrower in a syndicated loan. Airbus as an issuer of international bonds. In both documents, it says If you or any of your subsidiaries breach a transaction document, then you're in default. It will then also say, by the way, another clause which says if your supplier, major supplier, Rolls-Royce is in breach of any of its agreement with anybody else out there, you, Airbus, are in breach. That is the full cross-default clause. And that is what the markets want to see. Yeah?
I was wondering, how can we avoid a breach of contract that is not
Breach of, because it could be a bond issue. So I'm trying to encourage you to speak like lawyers in the markets rather than contract law students. Anyway, please go ahead.
that it's caused by someone else?
It's caused,
By someone else, by another collateral entity. So how can we avoid this? I mean,
nothing, you can't.
We can.
You can't. You will be in breach. You can't stop Rolls-Royce breaching one of its loan agreements in this Airbus example. No, you can't. It's unfair. It's unreasonable, but that's the law. Somebody else had a question up there. Yeah. Oh, good. The markets will love you for that. Yep. What? Which law system are you from? Sorry, which country? Norway, okay. All right. Would you as a Norwegian lawyer be able to give an unqualified opinion to Morgan Stanley on a $2 billion value transaction saying, I, law firm, will assure you in our hard opinion that the cross-default clause is valid and effective even though the cross-default clause refers to a third-party entity which supplies construction materials to Norsk Hydro. Sorry?
Yeah, if it was a commercial client which negotiated with another party and they enter into the agreement with the gift. I would say 95% certain.
95% certain. That is where the problem lies, because not only would Morgan Stanley not like that, but don't forget, $2 billion is more than the value of your partner's homes. If that opinion is wrong, you'll find that many law firms will not give that unqualified opinion because they are put on the line, and if they get it wrong, they are in serious difficulty. Sorry? I agree with you entirely, but if the judges can apply a fairness criterion, that law system has got a problem. Yeah? Okay. Moving on. What are the other factors that affect this choice? Another very important aspect of the process. This thing called the doctrine of implied terms that you find in many law systems. Courts are in the habit, judges are in the habit, in their wisdom, of reading into contractual documentation or transaction documentation clauses which are not written there for the benefit, once again, of reasonableness, fairness, blah, blah, blah. That, again, is not something that ExxonMobil or Norsk Hydro or Morgan Stanley like to see. When something is written down in black and white, clearly, that's it. They don't want judges to read anything into these documents. So the question is, how far can terms be implied by judges in the future after the transaction documentation has been drafted and settled? Well, many a law system has this rule that if it's reasonable and it achieves fairness and justice, then judges can actually read into the document, i.e. put into the document, clauses which are not written on an implied basis. That is something that the markets do not want. Now, even under English and New York law, there is an implied terms doctrine enabling courts to write into a document implied terms. But that is done and can only be done when it is absolutely necessary to enable the contract, the transaction to work. No other reason. Not reasonableness, not fairness, not justice, none of those reasons. So, that is a major aspect, once again, of the choice of law process. No implied terms. No power in judges to put clauses into the documents, into the transaction documents, which have not ever been written by the counterparties, parties, lawyers. Here's one which came up in 1977. English common law case said, the court will not improve a contract by reading something into that contract on the grounds of fairness, reasonableness, etc. This was explored in the context of a syndicated loan recently in 2002. What happened there was a syndicated loan has its usual clause which says if the majority of lenders want to call a default when a borrower breaches the agreement, they may by a majority do so, full stop. So in this one, the majority of lenders decided they wanted to call a default on the borrower and did so. The minority didn't want to call a default and they went to court to stop it. And they said, well, surely the court should imply a term saying that the decision of the majority to call a default should not prejudicially affect the minority. Court was very clear. No implied term. Even if it was necessary for justice, fairness, reasonableness, blah, blah, blah. Irrelevant. So once again, this concept of the implied term. Now here I'm going to draw your attention to those legal clans again. One set of law systems, the so-called common law system, adopts what is called the expressive approach to transaction documentation and interpretation. Others, which is the rest of the world, I think, use what is called a purpose-driven or purposive approach to interpretation. They will look at the transaction and say, what was the purpose? Excuse me. What is the commercial purpose of this transaction? What is the commercial purpose of this clause? And we will interpret the clauses, the documents, in accordance with that commercial purpose. Fundamental divide between what is called the expressive group of law systems and the purposive law systems. The expressive law systems, i.e. essentially the common law systems, will say what is written is what is written. We will not look beyond what is written. Not interested. Yeah. You're going to have to speak up, please. Anti? I'm not following your question. Anti-clause? What does that mean? An anti-clause, A-N-T-I clause. What does this clause say, this anti-clause? Sorry, the... Oh, not anti, it's entire. Sorry, okay. An entire clause. Sorry, okay. The entire, yes. I mean, the entire clause agreement is simply one which supports no implied terms. It says this agreement is an entire agreement. Nothing else is involved in this agreement. It's an entire agreement clause. It shuts out all other implied terms. Now, that's actually, in many senses, unnecessary because the law systems in New York and in English law says judges may not read in, put in, introduce new clauses. But yes, you're quite right in drawing our attention to the fact that, yes, there is in fact a clause which repeats what the law says, the entire agreements clause. We'll come to all these things later. I mean, we're still dealing with the starting blocks. Okay, this is the fundamental divide between the expressive approach and the purposive approach of interpretation. But this has a huge, and I mean a massive impact when we start looking at something called moratoria and Article 8.2b of the International Monetary Fund Agreement, which I hope I will get to today. Just put a mark on it. Expressive versus purposive becomes terribly important when we are looking at something called moratoria. Anybody knows what a moratorium is? We'll talk about it in a little bit of detail. Essentially, it is a governmental regulation which seeks to interfere with the payment obligations of corporate entities within that jurisdiction. Argentina says no Argentine corporation shall pay or repay loans taken from any other foreign bank or group of banks and shall not pay interest in any foreign currency until further notice or for 5 years or whatever the period is. That's a moratorium. And we'll come to that in a minute, but I'm just drawing your attention to the relationship between the expressive approach and the purposive approach in relation to this whole question of moratoria for the moment. Now I'm going to get on to talking about some very basic things which are perhaps not legal questions, but which are important to the markets. The third, after result predictability and certainty, is conceptual sophistication of a law system. Now, nothing important in relation to conceptual sophistication when you're looking at traditional international financial transactions like syndicated loans or bonds. But once you get into novel products such as derivatives, derivatives netting, credit derivatives, project finance structures, or synthetic securitization, this becomes rather important. Why? Because some law systems will not recognize novel financial instruments until their government, their central bank says, yes, that's okay. Under English and New York law, if something is not overtly and clearly illegal, it's recognized, however sophisticated and incomprehensible it may be to you and me as lawyers. And that's a huge advantage for the markets. It means they can create a financial instrument and it's immediately recognized as valid and effective under English or New York law, if that's the law chosen for these documents. And that is why a lot of the more sophisticated derivatives transactions, credit derivatives transactions, synthetic securitizations, and in particular in project finance structures, English and New York law is used, because otherwise you've got to go right back and ask your legislature or the central bank, please can you say this is okay, we can do this. Who's from Brazil? Okay, I ask you a question. Have you guys finally agreed that credit derivatives are okay to be done by, central bank regulation? Or are they still arguing about it and you can't enter into credit derivatives transactions? It's all right. If you don't know the answer, that's fine. But I just thought I'd...
We have derivative instruments and something that is possible to do. Yeah, so now and then there's something...
But it's a credit derivative, which is a massive segment of the market. I know because on behalf of a Brazilian bank, I spoke to the central bank some years ago about this, saying, can you please recognize this because your banks are disadvantaged, because you can't do credit derivatives. And they're all scratching their heads trying to work out, shall we make it okay or not? Now, the important point I'm making, not so much about Brazil. You don't need to do that under English or New York law. You don't need the blessing of a central bank. You don't need the blessing of a government. You don't need the blessing of a legislation to do a novel transaction. It's just, you can do it, unless it's overtly and obviously illegal. So, I think that's a key aspect of this concept of conceptual sophistication. You don't want to, take something else, something called netting in derivatives. Until about 10 years ago, many law systems from Italy, 10 years ago, 15 years ago maybe, France did not recognize it until special legislation had to be passed recognizing this derivatives netting structure. So you have these problems which seem to crop up regularly because of a difference in the way the law systems work. If you need administrative, central bank, or legislative authorization for a financial instrument, that law system has got a problem in relation to the markets, because the markets are producing new instruments every day of the week. You heard about derivatives. I haven't told you about debt derivatives, have I? Or weather derivatives. Every day there's something new that is created. Question, is that valid under the law system you want to choose? Ask the question on English or New York law. Absolutely no problem. And that comes back to this question of conceptual sophistication of the law system. Yeah. I don't know about Bitcoin because it's not a financial transaction that happens in the international markets. It's a game that you guys play somewhere on a computer. The day when there's a Bitcoin bond issue, we'll think about it. I'm sure it'll be fine. But for the moment, it doesn't enter the global markets. Moving on. That's conceptual sophistication. Now I'm going to tie in what I was saying about chosen law with jurisdiction. Somebody asked me this question earlier, but forum, jurisdiction. Fundamentally important as chosen law. But here's the point. In real life, unlike in conflict of laws classes in law school, where you ask the question, now what happens if you choose Japanese law and the jurisdiction of the courts is Italy? Hello? Never in the real world. A chosen law is always coupled to a jurisdiction in that same law system in order to avoid, once again, uncertainty and result predictability being eroded. So, to that extent, the choice of law is also connected with choice of jurisdiction. You've got to think about, the markets think about it in the same breath. Because you choose New York law, you choose New York jurisdiction. You choose Japanese law, you choose Japanese jurisdiction. Choose English law, English jurisdiction. You don't mix them up. So the question, therefore, that has to be looked at is, if you're choosing a law system to control a transaction, you must also look at its courts. How do they work? Now, yeah. I'm sorry? I have never seen anything which says regulated by EU law in a bond issue, syndicated loan, derivative, or anything like that. I wouldn't know, is a straight answer. You've seen a law, a contract saying EU law? Seriously? What is EU law on contract?
There was a loan agreement from European Commission to the government, like microfinancial assistance. The governing law said that it's governed by EU law.
It can't be.
And on secondary basis.
It can't be. Let me give you another example of EU law. European Financial Stability Mechanism, the ESM, and before that, the EFSF, where loans were being made by the European Commission, none other, to sovereign states within the EU. The governing law was not EU law. Can I finish the sentence? The governing law in both this was not EU law, it was actually English law, because it was recognized that you need a law system. EU law applies in many different situations, but it is not a law system with torts, delicts, contracts, and other rules which would apply in relation to a transaction. Consequently, I have never seen it. I don't know about microfinancing, because I've never done microfinancing. It's not part of international finance. So maybe they're doing something different in microfinancing. Can we please stay in this world? I don't know about Bitcoin. I don't know about microfinance for schools in Africa. I'm not saying it's bad. I'm saying that's not our world. That's not the world of the Clifford Chances, the Linklaters, and Goldman Sachs. So I think please do try and stay within the parameters of what we're looking at. It is fundamentally important. Because otherwise this course can go all over the place with your discussion ranging from what if, what if, what if. And that's why the what if, I said let's stay with the way the markets work. If you choose a law system, the courts of that law system will decide disputes in relation to that transaction. And to that extent, choice of jurisdiction is allied to the choice of law. So before you choose a law system, you also got to say, What about the courts of that law system? Are they good? Now, that's not a lawyer's question. That is a question which the markets want to know. The investment bankers, the Exxon Mobils, the hedge funds, the pension funds, the insurance companies. What are they looking at? They're looking at a number of things. One, what is the speed and efficiency of these courts? How soon can we get an answer? Speed and efficiency. Secondly, are there specialized judges who are able to deal with these transactional disputes? In other words, are the judges doing family custody cases one morning and next day it's an international bond issue? No. People don't want that. People want highly specialized judges to be able to do that. Third one, equally important, that recognition question. Remember recognition of the chosen law? This time it's recognition of the jurisdiction. In other words, if you've got a judgment of a court in Singapore, is it going to be recognized globally or is it going to be recognized regionally? What is the extent of the recognition of a decision? Then there is the question of the intangible, neutrality, impartiality, and integrity of the courts. This is soft law. I'm not going to tell you which courts are regarded as completely neutral, completely impartial, and have no possibility of the president interfering with the courts. But that's the question that markets will ask, that there is no nationality preference in the courts. So that if you've got a corporation from that country having a dispute with a bank or corporation from another country, there will not be preference given to the local company, the local corporate entity or the local bank. So these are the factors that go into it, but the recognition question is important. And here, once again, we have an EU framework which is fundamentally important. It's the EU Judgments Regulation of 2001. It's called Brussels I, which is tied into a similar agreement which covers the European Economic Area states, the Lugano Convention. But what is important is that once a judgment is given by a court falling within the EU's judgments regulation, it must be recognized across the EU, which is a huge advantage to a judgment given by a court in the EU. And that means if you've got English law, English jurisdiction, that judgment will be recognized right across, not just the EU, but also the EEA area, which is a huge advantage to law systems which have the benefit of EU recognition. Next, I'm going to go on to all the factors that go into this choice. Market familiarity. Now, you and I as lawyers will do all these analyses about recognition of judgments, the Lugano Convention, blah-de-yah-de-yah. You know what investment bankers will do, or bankers, or Exxon Mobil will do at a meeting? They'll say, okay, so what's the governing law? And before anybody can answer, they'll say, what the heck did we use in the last transaction? So there is a market familiarity factor which is operational at a level that you and I cannot control. They feel, yeah, we use this law or that law. They have a tendency to use that law system again and again because they're familiar with it. Results are predictable. Next comes a very important one, which is another one of those soft law things, language of finance. Rightly or wrongly, for the good or bad, the language of international finance is English. That means that you've got to use this language to put clauses, documents, into enforceable format. It's much easier to use the language which you've been using to negotiate and agree. Heads of terms. You'll realize this when you negotiate heads of terms, that in a transaction, 10, 15 different parties, many from different countries, will agree what are called heads of terms, the basics of a transaction framework and the documentation framework. That will be done in the language of negotiation, whatever that language is, usually English. To transfer that into documentation becomes a lot easier if you use that same language. The result is the language used in communications in the global markets also feeds into the language of documentation. Now, On top of that, there are other factors such as the global dominance of US investment banks. I mean, give or take Deutsche in Germany, Nomura in Japan, BNP Paribas in France, anybody else who's kicking the ball around is a US investment bank. With the result, they tend to opt for either New York law or English law because of the fact that they control most of the transactions, structure and manage most of the transactions. And then there's the other soft aspect, namely the emergence of New York and London as the global financial hubs in this market. And then there's item 10, which I'm going to come to, I hope, today. One of the biggest problems in international finance, moratoria. Interference by governments in international financial transactions. Whether we're talking Argentina, whether we are talking Russia 1990, whether we are talking Greece, whether we are talking any of these states. A moratorium is a fundamental interference with agreements entered into, transactions freely entered into. The point that's made here in item 10 is this. How are these moratoria and the attempt by governments to interfere with financial transactions and financial obligations dealt with by the chosen law? And here you will find a fundamental which I'm going to get onto hopefully today. English and New York law have adopted an extremely aggressive stance, an aggressive attitude towards moratoria imposed by countries in relation to their corporations, in relation to the obligations these corporations or banks have undertaken in the markets. Essentially, English and New York law, and I'll walk you through it shortly, have refused to recognize the moratoria imposed by Argentina or Russia or Greece or anybody else. Other law systems have not approached it in that way, and I'm going to walk you through those shortly. So, I think I talked to you all of this stuff. You regulate. Okay. Before I go on to moratoria, I'm going to talk about something I mentioned at the beginning of this lecture. We try to insulate a transaction from the impact of many law systems by choosing a chosen governing law on the basis of all these factors that we've just talked about. But it's not, as I said at the beginning of this lecture, it's not everything that the chosen governing law can control. You can't. There are many areas in respect of which other law systems will have an impact. And they've got to be looked at. And a solution has to be found how we, as market lawyers, deal with it. Well, the first and most obvious one is corporate capacity. The ability of a corporate entity to engage in a transaction in a lawful manner. Capacity. That also includes two other concepts. Has this corporate entity been duly set up, validly incorporated, and lawfully existing? Because otherwise the transaction is null and void. So corporate capacity. Now if you look at the law systems from the US to Japan to the EU, the law is very clear. Corporate capacity, i.e. including has this corporation been properly set up, is it validly existing, can it engage in this transaction, is a matter for the law of the place of incorporation of that corporate entity. So corporate capacity is outside the control of the expressly chosen governing law. It is in the control of the law system, which is the law of the place of incorporation. If you want to take an example, Article 1F of Rome 1 says exactly that. Similar is question number 2. Internal vires, powers. We were talking about the power of the corporate entity to engage in a certain transaction. It's very easy when you're talking loans or bonds. Most corporations across the globe, major corporations, would have the capacity to engage in it. But if you're looking at sophisticated, complex financial transactions, that may not be the case. And therefore, corporate capacity is a very important aspect. Allied to it is this question of internal vires, meaning although a corporate entity may have capacity to engage in a transaction, whether it's a loan, bond, derivative, or a securitization, has that corporate entity gone through the relevant internal procedures under its constitutional documents? That question is not a matter for the governing law. It's a matter for the law of the place of incorporation, again, and the constitutional documents of the corporate entity in question. It's called internal vires. And article, again, as an example, Article 1F, Rome 1 regulation expressly says internal vires are not a matter for the governing law, expressly chosen under the Rome regulation. It's for the law of the place of incorporation. It's outside the control of the governing law. Now, just to put this in some kind of practical context, that's the law that I've just given you. So what do we do in practice? Here's a Japanese corporation or a Turkish corporation going to enter into, shall we say, a securitization transaction, a project finance transaction. It's not good enough to write an opinion saying, yeah, corporate capacity governed by Japanese law, yeah, corporate capacity governed by Turkish law. Your client is going to say, so what the heck are we going to do about it? And the straight answer is, the corporate capacity issue and the internal vires issue is dealt with on a transaction-by-transaction basis on the basis of legal opinions from law firms in the country of the place of incorporation of the corporate entity. Now, how do we deal with that? There are express clauses in transaction documentation saying parties agree to provide opinions from specified lawyers stating that this corporate entity has corporate capacity to engage in this transaction and the corporate entity has gone through the relevant procedures in order to engage in this transaction. So an opinion is a necessary condition precedent to the transaction in order to deal with those two legal matters, internal vires and corporate capacity. A related question. Remember, this one says, are you duly organized or are you lawfully existing? A related question is, what happens when a borrower or an issuer of a bond or any other party to a financial transaction is merged with another corporate entity? What is the legal impact of that? Does the governing law control all of that, or do we have to look beyond the governing law? Couldn't hear you. I couldn't hear you, sorry. Governed by local law. You mean the law of the place of incorporation? Okay, right. Local law is not a great phrase. I think you, yeah, okay. I know, but I know what you mean. And this takes you back to a number of related questions. What happens when a merger occurs? And secondly, when a corporate entity suffers corporate debt? What law controls it? Now, what happens is actually discussed in a series of cases way back, 50, 60 years ago, anyway, 58 to 61, Greece's first crisis after the Second World War. There are a number of Greek bank cases which actually dealt with this problem, and I'm just going to walk you through it. You don't need to read the cases. It's all summarized in my book with the diagram, so you needn't take a photograph of it. What happened was this. Greek Bank B issued bonds, international bonds, under English law to investors who purchased the bonds. Greek Bank A guaranteed Greek Bank B's bonds. It was a guarantee given by this bank to honor the obligations of this bank, Greek Bank B, to bond investors if this Greek Bank B did not pay on the bonds. It was a guarantee. That guarantee was also controlled by English law. So you had an English law guarantee and an English law bond. What happened next? Greece was in financial difficulty. The Greek government merged these two banks, the guarantor bank and the issuer of the bonds, into one corporate entity, the National Bank of Greece and Athens SA. There was no mention of who's going to pay on the bonds anymore. So the bond investors said, wait a minute, all this merger stuff is fine, but we'd like to be paid on our bonds, please. And they went and sued the National Bank of Greece and Athens SA, the new corporate entity, in order to get paid either on the bonds or on the guarantee. Since both the guarantee and the bonds were subject to English law and jurisdiction, the matter ended up in the English courts. And what the court said was instructive. What they said was, to determine whether there was a merger between Greek Bank A and Greek Bank B, that's not a matter for English law. It's a matter for Greek law. So you have to look at Greek legislation to work out whether there was a merger between Greek Bank B and Greek Bank A. Step one. Step two, was there a succession to the assets and liabilities of Greek Bank A and Greek Bank B due to Greek legislation in National Bank of Greece and Athens SA? Now, was it a successor to the assets and liabilities of Greek Bank B and Greek Bank A? What law controlled it? Not the governing law of the bonds, not the governing law of the guarantee. It was Greek law. Therefore, one had to look at Greek law to determine the question, was there a merger between Greek Bank A and Greek Bank B? And secondly, what was the effect of that merger on the new National Bank of Greece and Athens SA? Was it the successor to everything that was with Greek Bank A and Greek Bank B? All of those questions were a matter for Greek law. Greek lawyers gave evidence, Greek opinions were obtained to show that yes, there was a merger under Greek law between A and B banks, that National Bank of Greece and Athens SA was the universal successor to the assets and liabilities of Greek Bank A and Greek Bank B. Then came the key question. What was the liability of National Bank of Greece and Athens SA on the bonds, on the guarantee? At that point, the English court said, fine. Greek law determines that all these mergers have occurred. It determines that assets and liabilities have been transferred to this new entity, National Bank of Greece and Athens SA, but that's where Greek law stops. The question whether the bonds have got to be honored in accordance with their terms, the court said was a matter for English law as the governing law of the bonds, and whether the guarantee was still a liability of the National Bank of Greece and Athens SA and had to be complied with was a matter of the governing law of the guarantee, English law. Therefore, court concluded, the bond investors could claim on the bonds against the National Bank of Greece and Athens SA. Have I lost you? If yes, ask a question, and I'll have a sip of water while you're thinking about it. And the guarantee, both, were a matter which would be controlled by English law, even after the succession. All that Greek law would decide is whether or not this new bank succeeded to all of the assets and liabilities of Bank A and Bank B, which were merged. And the answer was yes. Greek law determines that, but after that, liability is determined by English law in relation to the bonds. Who is liable is a matter for Greek law. What is the liability is under English law. It's a very good example of how the interaction occurs between the law of the place of incorporation and governing law. Don't read the case, it's pretty long. As I said, it's summarized, but if you're interested, please do read it. Yeah. If it's a transnational merger, that's Greek Bank A and German Bank B, creating a new bank. Now that bank has got to be incorporated somewhere. Right? So you will look at the place of incorporation of this bank, you will look at the place of incorporation of that bank, and that one. So you look at Greek law and German law to say, well, what happened to these banks? Were they merged or no? If the answer under Greek law and German law is yes, they were merged, you then look at the new bank and its corporate capacity and say, what is it, what status do you have? Answer, you are the successor under whatever law, let's say this is Italian law. The new bank will have status and capacity, and the question whether they succeeded to all of the assets and liabilities will be a matter for Italian law in relation to the new bank. So at each point, corporate capacity has got, that law needs to determine what happened. Once the determination has been made under the relevant law systems, you then look at the governing law in relation to contractual obligations, bond issue obligations, and the like. Yeah, are we clear? Please do.
What could happen in the case that is there anything that we could use Greek law instead of English law? Kind of, could it happen some?
What? Give me the question again.
I think current, the English law was used as a guarantor's law, yeah?
It was the law of the guarantee, and it was the law of the bonds.
So how could this possibly be a Greek law, not English law? Like
What?
the case,
When you say, how could this be English
because
law?
I don't understand.
Wait, what is the this referring to?
This for investors, it was like simply it's simple for me that English law, it's such English law.
Yep.
And why should it be?
Well, if you would ask the question, Greek Bank B doesn't exist, Greek Bank A doesn't exist, so who am I going to chase? I, the investor. How do I know that this bank is liable?
I don't think that it's not that simple, because it's a successor for that.
What law tells you that? It's not English law, it's Greek law. And that's why you do need to look at the law of the place of incorporation to determine the very question that you just very correctly thought about. Succession.
Yeah.
What law controls succession? Answer, law of the place of incorporation.
And that's, then it's clear that it should be English law, yeah?
After that, then English law applies. But it's not as easy as that. I mean, I don't want to get into the discussion in the case law in that case, but let me give you the question and you can go away and think about it. The Greek government, after this judgment was given, then passed further legislation, which was discussed in another case, which was, okay, wait a minute. No, sorry, it's not there. It's called Bank of Greece and Athens SA and Metlis was the follow-up case. Don't worry about it, I'm just going to talk you through it. It's not terribly important. What happened was, when this happened, the Greek government said, can't allow this. They passed legislation saying the new bank, National Bank of Greece and Athens SA, was not liable on the bonds issued to investors in the bonds.
Just cheating, because it's clear, clear.
Well, if you ask the question from a Greek lawyer, I mean, Greece, what answer would they give? They'd say, absolutely clear. The investors have no rights. Because this is Greek law, right? But this came back to the English High Court, and they said, well, once we have now established that the National Bank of Greece and Athens SA was established under Greek law, lawfully exists under Greek law, your answer succeeded to the assets and liabilities of the A and B banks, a Greek decree cannot affect the rights of investors under the bonds, because those rights that the investors have are not Greek rights. They are English law rights. Therefore, a Greek government decree cannot interfere with those rights. Good, I'm glad you thought it was obvious. So they had to go to court to decide this. So anyway, right, that's really one example of the interaction between the governing law and the question of corporate capacity. Right, there are lots of other exceptions, and I'm just going to run through them because I think at this stage, all you need to know is there are all these exceptions to the control of the governing law. That's all. Securities laws. Laws controlling the bond issues. Laws controlling share issues. Securitizations. Applicable in major jurisdictions, or indeed many jurisdictions, have an override. And the most important one, as you might have guessed, is United States securities laws. They are globally applicable and need to be globally complied with. You'll find that out when we go along in the course. but they need to be complied with. They are an override. They supersede the governing law. Second one, transfers of assets. If assets are transferred in the course of a transaction, best example, project finance or securitizations, where assets are transferred from corporate entity A to corporate entity B, sometimes a special purpose vehicle company. What law controls that asset transfer? Well, the contractual aspects are controlled by the governing law of the transfer, but whether the transfer is actually valid and effective is governed by the law where the assets are located. So if you've got an oil pipeline running from Kazakhstan to Turkey, and that oil pipeline is transferred in the context of project financing, well, supposing it's New York law controlled documentation. Yes, New York law will control the rights and obligations of the parties to this transfer. But whether the oil pipeline has been properly transferred depends on the laws from Kazakhstan to Azerbaijan to Turkey. Those laws will have to be looked at. How do we do that? Once again, legal opinions from lawyers in those countries certifying that the transfer has been effectively achieved under the relevant law systems determined by what is known as the lex situs rule. You know what we lawyers are like? When we can't think of something, we always use Latin. It simply means the place where the asset is located. Okay, for those who didn't have the horror of learning Latin for 6 years in school, as we all did. You know what they used to say, don't you? How many of you did Latin in school? There you go. You remember what they used to say, right? Latin is a dead language, as dead as they can be. First it killed the Romans, and now it's killing me. You know, that's what we used to say. Sorry, you had a question. Somebody had a question. Please do. I think I have to speak up. There's somebody shouting at the back.
So this lex has the Greek bank example, for instance, if I'm the investor, I know the English court has ruled that.
Wait, go slow. The Greek bank cases deal with capacity. Yeah? Whether a corporate entity has been set up, is alive, lawfully existing, or has been merged and is dead or liquidated. That's governed by the law of the place of incorporation. This deals with transfers of assets, whether it's oil pipelines or factories or whatever. And the question is, what law controls that? Well, of course, there will be a transfer agreement if you're transferring an oil pipeline or indeed transferring a factory from A to B. There will be a transfer agreement. But the question whether the transfer is effective under applicable law, one has to look at another law system as well, namely law where the asset is located, the factory, the oil pipeline, or the gas installation.
So transfer of assets, does it include payments to a given person?
No, we're talking assets, asset location. A right to payment could, I mean, if this is your question, a right to payment. Supposing I have agreed to pay interest to you, right? Your right to receive interest is an asset in your hands. So the effectiveness, but there's no transfer of this asset, is there? I'm paying money to you and that's it. But if you were to transfer that asset to some third party, I don't want to get into securitization, but let's suppose in a securitization, you have rights to receive interest from a whole number of borrowers. Those are rights in your hands. Yeah? Loan rights. In a classic traditional securitization, you, as the person with the rights to those interest payments and loans, will transfer them in a securitization to a special purpose vehicle company under a transfer agreement. Is the transfer agreement valid? Matter for express governing law. Is the transfer of the asset valid by another law system? Yes, you've got to look at the location of the asset. So if it's a right to payment, question, where is that right located? And that law will decide whether the transfer has been made effective. It will come up again and again when we look at Finance 3, asset transfers. Okay, a similar rule, security interests. if security is granted over an asset, you won't see it in loans and bonds in financial markets, but in securitizations and project finance, yes, you do. Asset security is granted over assets, whether it's a mine, whether it's a gas pipeline or an oil rig, asset security will be granted. What law controls the asset security? Once again, the grant of the asset security will be governed by a controlling law expressly chosen in the transfer document. But the creation of a security interest over the oil rig, for example, a charge, if you want to use a word, neutral word, a charge, a security interest, will not just be a matter for the law governing the document creating the security. It will also be a matter for the law of the place where the asset is located over which security is granted. So, for example, an oil rig off the coast of Norway. Security is given by Norsk Hydro to a group of banks. What law controls it? Well, the transfer agreement, there's a governing law. That will decide rights and obligations of parties. But whether or not the security interest granted is effective will depend. If the oil rig is in Norwegian waters, will be referred to Norwegian law, because the security interest can only arise and be effective under the law of the place where the oil rig is situated, in this example, Norway. Okay, excuse me. Next one down. Also outside the control of the governing law, negotiability of financial instruments. Now, this is a concept I'm going to have to come to later, but I just mention it for those of you who know what negotiability is. It's, lack of a better word, in a very simplistic format, it's transferability of a financial instrument. Checks, bonds, shares, whatever. Again, certain aspects of negotiability falls outside the governing law. For the moment, I'm not going to deal with this one, because the only thing that we will deal with, which is a transferable instrument, is a bond, or a GDR, or a medium-term note, MTN. And when we come to look at them, you'll realize, when we talk it through, that the old concept of negotiability is now a dead letter. It's wholly irrelevant in the context of the markets. So the law governing negotiability is equally, utterly irrelevant. But let's leave it for the one side. Let's park it till we get to bonds, okay? Next one down, insolvency. Governing law has little to say on this subject, has no control over it. The insolvency of a corporation or a bank in these markets will be completely controlled, entirely controlled by the insolvency regime applicable to that corporate entity. No other law system can interfere with the impact of insolvency, because it will be controlled by the insolvency regime applicable to the insolvent corporate entity. Under many law systems, that would be the law of the place of incorporation. Lehman Brothers, law of the place of incorporation, New York. But there are many other law systems, in particular EU law systems, where it's not the law of the place of incorporation, but it happens to be the place where management control is located. You don't need to go into all that. All you need to remember is that in insolvency, the governing law becomes irrelevant. What happens is that the insolvency law applicable will take over. Finally, and I think that's about all the, oh no, there's more. Trust structures. To anybody who's not a common lawyer, a trust is some strange animal found only in the common law, true. But the question that happens is as follows. If in the context of a global financial market transaction, a trust is set up, and they are set up very frequently in order to achieve certain financial objectives in the context of finance. Project structures, project finance structures in the context of securitization, they're used. Trust structures. Question, what is the status of the trust structure? Now, the trust will usually have a governing law. Now, inevitably, that will have to be New York law or English law or a law system which recognizes trusts. But that's not the end of the story. Because once you set up a trust structure, the trust owns property. There will be a document under English law or New York law setting up the trust structure. Question, what is the effect of setting up a trust, assuming, for example, it is set up in the Netherlands Antilles? By the way, that's somewhere in some nice place in the Caribbean where you can go surfing. What is the validity of that trust? Now, answer is very straightforward. It's not simply controlled by the governing law of the trust document. There are recognition rules that have to be applied as to whether or not that trust is recognized outside the governing law of the trust structure. So, in my example, Netherlands Antilles law will have to be looked at to work out whether the trust structure works, is recognized, and is effective. Now, to get over this kind of problem, because trusts are so regularly used in financial market transactions, a new convention was, I shouldn't say new, 1986, way back, to require recognition of trusts by different governments. Unfortunately, very few countries have actually signed and ratified the Hague Convention on the recognition of trusts. So for the moment, one is reliant on laws in individual countries as to whether or not they will recognize the English/New York law-based trust structure used in international finance. But again, one more area which is outside the control of the governing law of the trust structure. Then comes non-contractual obligations. In the context of transactions that we are dealing with, there are all sorts of things that happen which can go wrong. I mean, they do go wrong. Yes, it's usually controlled by the transaction documentation, but sometimes it can't be. The best example is a very simple, straightforward example from a syndicated loan agreement. Before 200 banks engage in a syndicated loan, a bank called the lead manager, which leads the whole transaction, will prepare something called an information memorandum about the borrower. It contains all the necessary financial information. And from London, New York, or Frankfurt, or wherever it is that it's being done, that lead manager will press a button and send this document out, containing information about the borrower, to hundreds of banks across the globe, to Singapore, to Sao Paulo, to Mexico, to China, to Tokyo, wherever. Now, next question. Supposing there's misinformation, as it quite often sometimes happens, in that information memorandum. What's liable, who's liable, and what law determines liability? Now that's not a contractual question. There's no contract. It's just a document containing misinformation which has gone out, somebody has relied on it, and later suffered loss. What law controls it? Well, this is called the question of liability for non-contractual obligations. Common law systems call it a tort. Civil law systems call it a delict. Others call it simply a civil wrong, and so on. Different law systems apply different rules as to what law controls liability for that information memorandum which has winged its way across the globe. Well, let's just very quickly try to understand how liability is determined. First of all, I'm going to give you the old law. The Napoleonic-based law systems, the Romano-Germanic law systems have something called the Lex Loci or Lex Loci Delicti rule. Where did the wrong take place? The place of the wrong. Now, if the misinformation is sent out from Frankfurt, it may be that the Lex Loci Delicti rule under German law will say it's right here in Frankfurt. That's where the document went from. In the US, the rule is contained in the American Restatement of the Second Conflict of Laws. It's not the Lex Loci Delicti. It is the law system with which this delict or wrong has its most significant relationship or connection, substantial connection rule. Now, by now you'd have realized that what law will apply to decide liability for that information memorandum will now turn on where is the dispute being litigated. If it's in Germany, you'll have a lex loci delicti rule. If it's in New York, it will be this one, the law system with which the transaction has its closest connection. And the old English common law, which has been abolished now, said it was a lex loci delicti, like German law, unless the tort had a close connection with another country. In other words, it's a double test. Now we've got a new regime, at least within the EU. The EU's Rome II regulation, not Rome I, it's Rome II regulation rules as to what law controls liability for non-contractual obligations. But please remember, it applies only after 11th January 2009. You got a question? Go ahead, please. You're thinking about? Okay. So what is the Rome II regime that we now apply across the Union and in English law? The primary rule is not the lex loci delicti, i.e. the place where the wrong was committed, but where the damage occurred, lex loci damni. Who suffered damage and where was it suffered. That law system where damage was suffered will determine liability. But there's a second rule, in addition to the primary rule. If you've got a question, please ask. Your neighbor does not know the answer. Got a question? Please ask, because don't let it go and ask your neighbor and then go home and look at lecture capture and think, God, what was he talking about? And I understand that because this is a complex area. It's full of rules, and unfortunately these rules are going to permeate, affect all the transactions we're going to look at from now till end of semester 2, whether it's in this module, Finance 2, Finance 3, whatever. And that's why I'm walking you through it slowly. And I'd like you to understand it, and if you've got questions, please, I'm not a French law professor, so I won't shout at you. Please ask whatever question you want. Okay? No, I didn't say French law professor. They're nice. But French law students have a different viewpoint. Anyway, come back to jokes apart. The Rome II regime has got, therefore, a secondary allied rule, where the civil wrong is more closely connected with another country, i.e., another country in addition to the place where damage occurred, lex loci damni, then that law would override. But with regard to this nice information memorandum which has been sent across the globe by Morgan Stanley, we have a much better solution now, a very advanced solution which is only found in EU law. It's not found in US law, it's not found in the US restatement, it's not found in Japanese law. It's a very, very important rule. It's the Article 14, 1B rule in Rome Regulation 2. This enables parties to agree in writing that all non-contractual aspects, including torts, delicts, and civil wrongs, arising from a transaction, can be made subject to a chosen law, chosen by parties and expressly set out in writing in an agreement. You do that, that's it. You ignore lex loci delicti, you look lex loci damni, all those other rules are gone. All you have is, what have you chosen? What law have you chosen to apply to any civil wrong arising from this transaction? It's an extremely advanced rule. It's obviously a parallel to the Rome I rule, which says you can choose a law to govern a contractual transaction, it will control all aspects of that contractual transaction. Similarly, Rome II says you can choose a law system which will decide the liability for any civil wrongs, torts, or delicts. It's a huge advantage. But you need to put it in writing. Now, in practice, that agreement in writing is to be found in loan documentation and in bond documentation, providing that, simply saying that if there are associated torts, civil wrongs, delicts, they will be subject to the following governing law, usually the same governing law that controls the contractual documentation. So that's Article 14(1)(b), which is an extremely important aspect of the applicability of law systems in relation to transactions. We've then got unjust enrichment. Please don't ask me to explain it, because everybody's written at least 600 pages of a book to explain what unjust enrichment is. So we're not going to be concerned with it. All we are concerned with unjust enrichment is simple. What law controls unjust enrichment? In the context of a transaction, if one party is unjustly enriched at the expense of another, what controls? Usually it's resulting from money wrongly paid. Answer, Rome II again provides an answer which is not found in US law, but within the EU, this rule applies. Whatever the contractual relationship is governed by, what law controls that relationship, will also control the mispayment, the wrongful payment, which results in unjust enrichment. That again is quite a useful rule to have. Final one, which I think, let me try and get to the bottom of this, and I'm done, I think. Yeah. This Roman and Romano-Germanic concept, culpa in contrahendo. Namely, let me explain it very simply to you without going into the details of it. It is simply that if parties are negotiating to enter into a contract, and those contractual negotiations break down due to the fault of one party or due to non-disclosure of material facts, what is the position? Is anybody liable? Well, let me tell you what the English law is, and then I'll go back to it. English law has always had something called subject to contract rule. It means that all negotiations before formal documentation is signed is quote-unquote subject to contract. So whatever the cause is for the breakdown in negotiations, you can walk away with no liability. That's the subject to contract rule. Unless there's misrepresentation, in which case you're into Article 14 Rome. But otherwise, there's no liability if you've got a subject to contract clause governing your negotiations. That is not the position under German and French law, where there is a culpa in contrahendo rule, meaning liability for breakdown in negotiations due to the fault of one party rather than the other. So, this is a fundamentally important difference between English law on the other side, New York law on one side, and continental European systems on the other. The new rule is contained in Article 12, Rome II, applicable across the Union. It is this, that if there is a breakdown in contractual negotiations due to the fault of one party rather than another, then what law controls liability for breakdown in communications depends on what law would control the transaction documentation which would have resulted. So let's take a simple one. Syndicated loan. You're negotiating things, you sent information memoranda out, but before the syndicated loan agreement is signed, borrower walks away from the transaction. Is there liability? Well, answer is Article 12(1) Rome II. You've got to ask the question, what is the law which would have been applied? By the way, none of this is in my book, so if you're not following it, please say so. Your neighbor has no answers. Okay, let's hope you can watch the film and work it out. What this rule says is you have to ask the question, what is the law that would have been the governing law of the transaction documentation if the transaction went ahead? That law will control liability for breakdown in communications or negotiations before the contractual documentation is signed. That's the Article 12 rule. Give me a minute, okay? Now, you might think, how the hell do you find out what would be the law that would have been applied if the documentation would have been signed? In real life, the answer is very simple and straightforward. In every syndicated loan, in every bond issue, in every securitization, in every derivative, in every project financing, there is something called a term sheet which is produced. A term sheet. It's not a contractual document, it's a term sheet. It says, here are the terms that we're talking about. And in it will be one more thing. Final documentation shall be governed by New York law, English law, German law, whatever. The Article 12 rule, therefore, says, well, what would have been the law that would have governed the transaction documentation? Answer is very simple. Look at the term sheet. It's that. That law, under Article 12.1, will decide liability for any breakdown in negotiation resulting in no agreement at the end of it all. Oh, Lord, things are really looking bad, aren't they? I'm just looking around the class, and there are faces which are saying, please get me home. I need... Please, once again, if you are not happy with talking about this stuff in class, and I mean the class of 200 people here, what I would strongly urge you to do is either talk to me after class, or if that's not possible because you haven't yet thought about the question, then wait for the seminars. Seminars will commence, I hope, if not next week, the week after. Please come into your first seminar with a list of questions and ask, okay? Otherwise, don't let it go till March. Or don't let it go, forget March, don't let it go till end of November. You're dead in the water. You can't follow it, okay? So please, I'm asking you again and again. Questions, come with them, discuss them, get it clear. Now, your question. I answered it in advance, so that's good. Right, moving on. Oh, question. Sorry? Under New York law or any common law system, what you will have is the rule of subject to contract. No liability. No liability at all provided your negotiations have been done under a letter which is standard of subject to contract. That's a standard common law procedure where parties say all negotiations, all discussions are subject to contract. So we don't have this problem of culpa in contrahendo under English law, but the problem is that the moment you step outside the common law systems, you've got liability in Germany, France, Italy, everywhere else. And that's why this Rome II rule is terribly important. Yeah.
So, term sheets very quickly. How do you decide which law is the final one? So say one party has New York, one party has English. On a term sheet, how does that work?
No. One party doesn't say, I want English, and one party doesn't say. It is in the term sheet saying, if you are going ahead with this transaction, guys, this is the governing law in the final documentation. Now, if parties are saying, well, I want English law, somebody else I want German law, somebody else says I want Japanese law, they've got to decide which one is. And that will be then included in the term sheet in practice. Okay, I'm going to stop there. Hang on. Whoa, I won't stop there. How many of you guys have filled up the form that's going around the class? Oh, Lord, is that all? So the guys behind you haven't even got to it. I can't do the seminar groups unless I get that form back today. So if you've got 5 minutes, can you please fill up that form before you go away? Okay? Could you do that? You want to please? All you have to do is say no T4, no T6, or no Wednesday, whatever. Okay? That's all you have to do. All right. If you can just fill that up, I will try and get these seminar groups together. Not yet. I mean, I gave everybody 4 weeks deadline.
Okay.
Hi. Go ahead. Please ask. Oh, hang on. One more question for you guys. Boop. How many of you... Hello. One question for everybody. One question. How many of you in this class have applied to be Pathway Secretary for International Financial Law? Okay. Could I very quickly, for 5 minutes, just now, outside the class, can we talk? Okay, good. That's all. And we're now going to leave because we're going to be thrown out. Can we go outside? We've got to go outside. Sorry? No, I didn't say anything about the practice model. I said there's going to be a pathway secretary appointed to look after the international financial law pathway. If you applied for it, I'd like to talk. You haven't, then don't worry. Okay, this is completely different. We're talking about people applying to be pathway, IFL pathway secretary. Administrative role, that's all.